What's up, guys? So today I want to talk about what if you do business with a company that is dissolved and not active? What if you sign franchisees contracts with a company that's not active and dissolved? Um, what actions can you take in court? How do you approach that in a lawsuit? Um, Again, if you can imagine a company, um, imagine we have a balloon, and I'm going to try to put this in simple terms. Imagine we have a balloon, and in the middle of that balloon, you have a little guy floating in the middle of the balloon, and the balloon's surrounding the guy, and around the guy is a home, a car, a family, their kids. Everything personal surrounds the guy. When you go to court, the balloon is like the corporate veil surrounding that little guy in the middle and protecting that little guy and his home and his family from any lawsuits brought up on the corporation. Well, if you act in a deceptive manner and you don't have an active business and your business is dissolved, the judge can actually pierce the corporate veil. And in this case, imagine that balloon, the balloon literally gets popped. And what becomes liable for the lawsuit is everything inside the balloon: the floating man in the middle, the house, the cars, everything personal this guy has worked his entire life for is now vulnerable to a lawsuit. There's no more corporate veil. The balloon's been popped. And the judge can order that based on several factors. When a business is deceptive, they don't have a business, it's dissolved. They were operating like they did have a legit business and they really didn't. They're scamming people. Um, because if you don't have a legit business, then you can't bring a lawsuit against the business because the business doesn't exist. It never existed. So, in manners of that such, you can actually pierce the corporate veil. And to do that, a lot of times you got to establish legally what they call an alter ego. And I'll go into details and explain what an alter ego is. Um, but first, in the beginning, so I've heard a lot of people out there say BAM Franchising Incorporated didn't have an active business in Utah, and that is incorrect. They did. They just haven't had one in a very long time. As you can see here on the state website, BAM Franchising Incorporated was registered in Utah, and the filing date was 2020, 10/21/2020. It is inactive, and again, I went into this on my last video. It's been inactive since 2022, so it's been inactive for 5 years. And the reason I think it's been inactive is the most common reason. If you don't file your annual reporting as a limited liability company or corporation, by default, the state will automatically dissolve your business within 2 years and it will become inactive. So, going back to that clears that up. So then we saw this BAM Franchising Incorporated filed recently on the 9th, 2026. And again, what I think they're trying to do, I don't want to give this corporation a lot of credit. I've heard a lot of theories out there and a lot of people trying to make this very sophisticated. Like they're really making some legal moves and corporate structures that are way beyond what we could typically understand as far as the layperson. But I think it's pretty simple, and I think it's just they're dumb. Literally, they're dumb and they're just scandalous. All this whole thing is a scam. So I think they created this company on the 9th, 2026, because I think they're going to bring this into they're going to pretend like this was the active business the entire time they've been doing business. And the only way the judge will know that, the name is exactly the same: BAM Franchising Incorporated. Two listings here. One's inactive, one's active. So the only way you know if you're suing the right company is if you look at the entity number. That is very easy, even for professional lawyers, to look over when filing a lawsuit, because what you're going to look at is the business name, and you're going to see it says BAM Franchising Incorporated, and you're going to think you're suing the right company in Utah, unless you look at the entity number and realize, oh wait, this entity number they put on their document started July the 9th, like 10 days ago. This is not the correct business. Again, that is a new business, and it can only take on the liability from when it started. So I think that's them trying to be deceptive and really just slide this in like that was their operating business the entire time in Utah. But, you know, let's move on because there's some other issues. So the franchisees sign an agreement with BAM Franchising Incorporated, and they sign that agreement based upon BAM Franchising Incorporated's registration in Oregon. But if you go to Oregon and look at their registration status, it is inactive as well. So it's not a legit active business there either. And it's been inactive since 2024. So essentially all the activity that happened during such time, in reality, there has been no active company that all that activity, the lawsuit could be brought against because the company was inactive and dissolved and it never existed. In legal rights, in a legal authority, it never existed to act as a business. And again, you can act when you have a dissolved business, you can only like liquidate, pay your debt, and close the business. You cannot give people the perception that you have an active business, and you cannot take on new franchise contracts and new business. You can't grow the business. You're not a business. You don't have the legal authority of the state to conduct business. Their trademark, this is very interesting. Their trademark for Bricks and Minifigs was not approved until 2026. Like, I mean, this is something you're selling your franchisees. One, to understand how a franchise works, the franchisees open up and own their own LLC. Their business stands alone as an independent business. The only thing that ties it to a corporation or the franchisor is a contract. And the contract in this case, Bricks and Minifig offered the franchisees a couple of things: their reputation, their brand, their marketing, basically the corporate structure and their name. Well, their name is absolutely being diminished, and it was, they didn't even have the trademark rights through the federal system active and registered or live when they were selling these franchisees their brand and logo to use as marketing. So here we go. This is live, Bricks and Minifigs. So if you look at this one, Bricks and Minifigs, this one's live, that one's live, this one's live. And you look at this and you're like, oh, that's cool. Yeah, great. But let's click on them. So if you look at the registration date, that is the date, that is the date that it is officially a trademark. Like, you own the rights to trademark that logo, that name, that brand. And if all these went live, meaning live, they were officially approved, all these went live in 2026, like 2 months ago. And I mean, this is absolutely crazy. The trademark isn't such a big deal because you can still operate using that logo, using the name. But the thing is, what this protects you from is like people still, other people are not allowed to use your logo and your trademark while you have that trademark approved and it's yours and it's live and it's registered, right? That protects you from other people being able to use your name. But up until 2026, this trademark could have been used by anyone. And again, this is what they sold to their franchisees, right, as part of the package. Because again, the franchisees stand alone as an individual LLC. They stand alone as their own company. The only thing that ties them to BAM Franchising Inc. is a contract that they both signed and went into. And the contract here offers them a corporate structure as far as brand advertising and marketing, pretty much. I mean, when it comes down to it. Um, but let's talk about that contract, because that contract was signed assuming the business was not dissolved, assuming the business was active business, and assuming the business was legit and practicing ethical, operations with their corporation. But come to find out, like, that's not the case. I mean, they couldn't do something as simple as filing their annual reports to keep their LLCs active. And like, so I stopped right there, and I don't want to give them any more sophisticated credit as far as them being able to, uh, in a clever way, structure their corporations to avoid lawsuits. I think they're just idiots, dumb, irresponsible, and they're absolutely doing business a illegal way. I don't want to give them no credit for being smart or clever and deceptive as far as like legally structuring a corporation to avoid a lawsuit. No, they're not that smart. This is just irresponsible and dumb. And what they're trying to do is make it look legit. They're trying to make their documentation look legit right now because they're coming into the public eye and they're being sued. That's why. So part of piercing the corporate veil, the first thing I would assume the lawyer is going to do, this is a franchising agreement, and I wanted to show you guys something important with this franchising agreement. And if you look at my cursor right here, it says BAM Franchising Incorporated and Oregon Corporation, right? Now look, this corporation has been dissolved since 2024. Dissolved, that means not active. Like, this is a huge thing. It means you cannot do business as this corporation anymore. And then you go back to Utah, and this corporation's been dissolved since 2022. Right there, expiration date 2022. There's no renewal date. So the one thing I assume BAM Reckless Ben and his lawyers are going to do is file for discovery. And the discovery request is going to be on, it's referred to as the plaintiff's first request for production of documents pertaining to corporate records, business entities, and trade names. What this is going to do, the court is going to demand for BAM Franchising Incorporated to send all documents and articles relating to the business as far as when it was created, when it was active, all their trade names, nicknames, umbrella companies. It's really going to expose the entire business structure. That way you know who you're bringing the lawsuit against, right? I think Bricks and Minifigs is going to have a real big problem doing this because their companies have been dissolved clearly and it's clearly documented on state websites for the public to see. So I think, again, going back to this Utah case, if you get a discovery request to provide, documentation and business records, I think they're going to try to slide this new one in as it was the acting business for the last 10 years. I really do. And the only way you would know the difference is if you look at the entity number. But this franchise agreement shows you who you're doing business with. These franchisees signed an agreement with BAM Franchising Incorporated as a Oregon company, corporation. If that is not true, if that company is not active, if it were dissolved during this time, this whole contract has major, major issues. Not so much for the franchisees, but definitely for the BAM, Bricks and Minifigs, right? BAM Franchising Incorporated. Like, this is deception. This is business deception. This is doing business in this scandalous way. It's like you're trying to be shady. You're trying to be very deceptive, and you're trying to talk people into doing business with you, pretending like you're a legal company, pretending like you're an active company, and you're not. And this goes to alter ego. This is something you got to prove in the court system. Basically, this is one of the steps. I'm not a lawyer. Again, this is just my opinion based on my personal research, but this is something that will have to be addressed, as if BAM Franchising Incorporated operated their business as a alter ego. Basically, the company was an extension of their personality versus the company being an actual corporation and standing alone, separate from their personal finances and their personal life and their personal decisions. And this is the alter ego doctrine, basically. And you get to this point if you've been deceptive, you illegally did business, and there's no corporation to hold liable, then you got to hold liable the people personally. And that's when the corporate veil can be pierced and you can actually go after them on a personal level because there's no company to bring the lawsuit against. So, just some factors. An alter ego is no real separation between the owner and the company. Ignoring corporate paperwork, such as annual reports. Here you go. This is what's required in the justice system to prove alter ego when it comes to business. Ignoring corporate paperwork such as annual reports or required state filings. This is clearly something they are 100% guilty of, and it's public knowledge. And when you can all look it up yourself and see this. And if you prove this alter ego, most likely you're going to pierce the corporate veil. You remember the balloon we talked about in the beginning? That balloon protects you, absorbs the liability of a lawsuit. But when you bust that balloon, when you pierce the corporate veil, personally, everything you own can be taken in a lawsuit. Oh, look, to go even farther, continuing to operate after the company has been dissolved while still presenting it is a valid business. You see, it's right there. Continuing to operate after the company has been dissolved while still presenting it as a valid business. This is clearly something that I personally, through my research, see them doing a lot of. Moving assets between related companies to avoid debts or legal obligations. Again, they own a company called Legally Mine, which teaches you to structure your assets in a way that you can't be sued or your assets are not going to be taken in the event of a lawsuit. This is called alter ego. This is like illegal, okay? This is major. Using the company as a shell company with no legitimate independent business purpose. Owners treating the company's assets as their personal companies. Why it matters: if a court determines a business is the owner's alter ego, it may hold them personally responsible for the company's debt, allow creditors and plaintiffs to pursue their personal assets, disregard the liability protections normally provided through or by a LLC or corporation. Again, you pierce the corporate veil. Treat the owner and the company as the same legal entity for purpose of the lawsuit. Again, if the company is not legit, if it's dissolved, you can't bring a lawsuit against a company that is not legit. The court will still allow you to bring that lawsuit, but they'll allow you to bring it on a personal level. And it's not illegal to sell a name and a logo. It's just you can't legally go after somebody for using the same name and logo if you don't have a registered trademark. And my argument to this is they were selling this to their franchisees as a package deal, like these were trademarks, when actually they weren't even registered, or they weren't live, they weren't approved until 2026. So legally, I don't know what type of responsibility can be held there, but ethically, I mean, how could you enter into a contract which is based primarily on branding and name And reputation, when your reputation, well, your name wasn't legally trademarked, nor your logos. And furthermore, your reputation's going on to hell. It's basically shit now because you ruined it. And the more people look into it, like it's none of it's making sense. It's really looking like this is going to be a fraudulent case, and you're doing illegal activities because you don't have a legit business, you don't have a business that's active, you couldn't file your annual reporting. Again, this all goes to you ran your business like it was an alter ego, like it was an extension of your personality. And in my opinion, they're in big trouble for this. I can't think about anything else right now. I know there's a Delaware company somewhere in there, but in my understanding, the Delaware company is tied to the Oregon company. The Oregon company is not legit. And anyways, in the franchise agreements, the company that's listed is the Oregon company. So I would assume jurisdiction lies in Oregon, and that will take all the liability and responsibility for the company. Because again, these contracts for these franchisees, I would seriously think like the franchisees, I don't think they have to look far to really get out of these contracts, especially with the issues with the annual reporting, the deceptive business practices, and just all the evidence out there that point to this company as like a shitty company, like just terrible. So I can't think of anything else right now, but what I can do is just bring a different perspective. And if you like that perspective, then subscribe and like, and I'll make more videos. Thanks. Peace.